Amazing. So, I am now pleased to introduce our speaker, Stefanie Davidson. So, Stefanie has been a professionally qualified archivist and records manager for nearly 30 years. Stefanie currently works at the West Yorkshire Archive Service and has responsibility for collections management strategy and development across the county, I should say, the county. She's previously worked in business archives and also in Scottish local authority archive services. So, thank you, Stefanie. Over to you.
Thank you. Hopefully you can see the first slides. The slides are showing all right, aren't they? I've shared my screen.
Yes, they are. Thank you.
Brilliant. Okay, so data protection today, big topic. As was said, I'm an archivist. I work currently at the West Yorkshire Archive Service, and I'm the records and collections manager there. So I am the person who's responsible for setting our policies and procedures for managing access to records and dealing with data protection matters that affect our collections. I'm also part of the Organisational Information Governance Board that we have in my organisation that deals with how we manage our personal data that we process as part of running the service. I also deliver the training for our regional community archives network group in West Yorkshire on legislation issues like data protection and copyright. One thing I am going to say before we start is there's slides coming. There's a lot of words on the slides. Don't worry about trying to scribble it all down. You will be getting a copy of the slides, so you will be getting that. You will also be getting a handbook resource, which will point you on to further guidance that you can look at online. Just another point is, while I am an archivist and records manager with a lot of experience, I am not technically a lawyer specialising in data protection legislation. So I will say again, nothing I say today can be taken as legal advice. But I am going to be providing an overview of data protection law in the UK and some of the questions that it raises for people managing archive collections. Having said I'm going to raise some questions, I'm not actually going to leave you with all of the answers today. If I do my job properly at the end of today, you may indeed have more questions. Questions it's going to be up to your group to work out the answer for how you work and for what type of collections that you hold. So UK data protection legislations. There's quite a lot of other pieces of current legislation that might be relevant to archive groups and institutions. Copyright Act, which I was speaking about last week. If you're a public authority, the Freedom of Information Act might affect you. Not generally a lot of community archive groups, but it might affect a community archive group who are associated with a school or an educational institution, perhaps. Rules about environmental information, privacy and electronic communication regulations, things like the Human Rights Act, Official Secrets Act, Public Records Act, all of these things are bits of legislation that might affect how you're dealing with archive material. The important thing is to be aware that these acts exist and might affect your work and not to memorise them necessarily, and also to learn where to look for advice on what you and your group should be doing. So, UK data protection law has undergone something of an evolution in recent years. So the EU GDPR, the General Data Protection Regulation, came into force in May 2018. And I know we all got endless emails from panicky businesses about it for months beforehand. The latest Data Protection Act in the UK, the Data Protection Act 2018, came into force at the same time. And that dealt with the UK derogations for GDPR, so the bits where EU members, which we were at the time, can choose their own approach to something within the regulation. It also, our Data Protection Act of 2018 also applied the EU Law Enforcement Directive, which applies to people like police, courts, the secret services, national security, and also bodies like trading standards. The General Data Protection Regulation, GDPR, did not vanish when we left the EU. The UK Withdrawal Act effectively created the UK GDPR, which for many reasons does pretty much the same thing. And there was a huge amount of publicity about GDPR when it came in. Some of it was less than accurate, and there are a lot of misconceptions out there, which hopefully I'll give you a steer on today. It is worth repeating, and I will again, that the changes in 2018 were simply an evolution of data protection legislation, not a revolution, as some elements of the press made it out to be. But there are some things that groups working with heritage collections need to be aware of and to consider their approach to. I'm also going to say that unlike quite a lot of our statutes, you can't really look at one piece of legislation, the Act or the regulation, in isolation. They work together, which is why there's that big plus sign. So one constantly cross-refers to the other. They don't stand alone. And as I say, they work together to form UK data protection law. You really can't read one without the other. More recently, as part of the Data Use and Access Act of 2025 last year, which the government passed, the government clarified some aspects of data protection law when you are carrying out what is called processing for archiving purposes in the public interest. As a result of which, bodies like the Archives and Records Association, working with other bodies, including the National Archives and the ICO, have been able to publish guidance on recognised standards to allow archives and community archives to easily demonstrate that they're carrying out archiving processing for archiving purposes in the public interest. Within the UK, the regulator for data protection is the Information Commissioner's Office, or the ICO. So what's data protection for in the first place? Well, data protection legislation exists to ensure that living people's personal data is dealt with in a responsible way by organisations that collect, use and share it. It can potentially cover all sorts of information in archive collections that are less than 100 years old, because we're talking about potentially living people. We generally assume a lifespan of 100 years. It may particularly seek to protect access to and the processing of what's called special category or very sensitive personal information. And it's relevant to photographs, other visual material from which it's possible to identify living people, as well as just written records. It can be relevant when you're planning archive projects like oral history collection or digitisation. And it also, for community archive groups, will apply to information that you hold for administrative purposes for running your group, not just the information in your collections. So data protection legislation in the UK is not new. We had an act back in 1984. There was an act in 1987 that governed access to personal files. And the EU directive of 1995 led to our first major data protection act, the 1998 Data Protection Act. So it's not going away. I will also say that when we're talking about the stuff that's covered by data protection law, this is generally about personal data that's being managed by organisations and businesses and groups that are doing it for a purpose other than a personal domestic purpose. There are exemptions for hanging on to or using or being in possession of personal data for domestic purposes. So if you have, for example, a Ring doorbell on your own house, then the images of people passing by, that's domestic purposes. It's not covered by Data Protection Act. If you're running a business from your house and your Ring doorbell is capturing the photographs of clients appearing at your business, then you may well actually be processing that data for under the Data Protection Act. So it's worth being aware of that. The EU regulation, General Data Protection Regulation, had broadly the same aim as our previous Data Protection Act from 1998. But what it was trying to do was to make sure that all countries across the EU did the same sort of thing in the same sort of way. The 98 Act had been based on a directive, which meant that each EU member state could choose to enact or not different bits of it with quite a bit of latitude for variation between us. GDPR was a regulation, which meant that it came into force across all member states in fundamentally the same way, with only a few areas where members could derogate their approach to particular aspects or choose their own path. The aim was consistency of regulatory approach. But like I said, the change from Data Protection 98 to GDPR was an evolution, not a revolution. Basically, Data Protection 98 was designed to make sure that data controllers, organisations that collect and look after and use personal data, did it in a fair and transparent and legally responsible way. GDPR did pretty much the same thing, but it also included stuff about how the data controller had to be able to prove they were doing things right, not just say they were. So that was the principle of accountability that came in. In addition, some data subject rights were increased and strengthened, especially around transparency and the right to know about people using their personal data, access, corrections and removals. Some things around getting people's consent for the use and reuse of personal information did change. If you were relying on consent to be able to process or use personal data, you might now need explicit consent and to be really clear about how and why you're collecting and using data. But consent isn't the only legal basis for processing personal data, which became one of those GDPR myths I was talking about. When we left the EU in 2020, the government maintained much of the previous text and intent of GDPR in the UK GDPR, which enables us to be awarded adequacy as a third country. And that makes it much easier for those who do business with the rest of Europe or might be transferring information to other countries within Europe. Last year, they passed the Data Use and Access Act 2025, which made some amendments to the text of the UK GDPR. The amendments I'll be looking at today were triggered when Schedule 5 of the Data Use and Access Act came into force in February of this year. And broadly speaking, they were designed to clarify what is meant by and needed to demonstrate you are carrying out this processing for archiving purposes in the public interest, to clarify matters around using personal data for research, archiving, or statistical purposes, sometimes known as RAS or RAS purposes. A new chapter, 8A, was inserted into the UK GDPR with Articles 84A to D, replacing what had been the previous text of Article 89, processing, which you'll sometimes see mentioned in guidance. Like all bits of legislation in the UK, data protection has its own language and terminology, which can have specific meaning. Do not even get me started on acronyms. But these are some of the key phrases you'll hear about and I'll be talking about today, and you'll see them in guidance documents, and you might need to keep a note of them. So personal data, when we're talking about personal data, is any information relating to an identified or identifiable living individual. Personal data can include, therefore, things like name, date of birth, weight, state of health, your eye colour, your address, your credit card number, your telephone number, a picture of your face, a picture of your tattoo, if you have one and it's particularly outstanding or unique. And under UK GDPR, it also now includes online identifiers like your IP address. And it's also worth noting that living includes potentially living. So for the purposes of this and other acts, when you don't know if someone's alive or dead, it's usually safer to assume they are, and also to assume that somebody could have a lifespan of 100 years. The data controller is quite important. So a data controller in the concept of data protection law is the person or organisation or body who determines the purposes for the manner in which any personal data is processed. In other words, if you're making the decisions to collect and have and do things with personal data, you're probably the data controller. The data subject that we sometimes talk about is the person, the individual the personal data is about. And processing is one word which covers a lot of ground in data protection legislation. So processing includes collecting, recording, organising, structuring, storing, adapting, altering, retrieving, consulting, using, disclosing by transmission, dissemination, or making available, combining, restricting, erasing, or destroying personal data. All of those things constitute processing. As I say, one word does a lot of heavy lifting. A data processor might well be any person other than an employee of the data controller who processes the data on behalf of the data controller. So that can involve secondary companies, like very often if you're using Eventbrite to do event management and ticketing, Eventbrite is acting as your data processor because you're the one giving them the mailing list to send out to send information on the event to. But they're the ones who are processing that information for you, and they have certain responsibilities still under data protection law. Sensitive, formerly sensitive under the old Act, but now special category personal data is very strongly protected by the legislation, and there are only limited allowances for organisations to even process it at all. If you have this type of personal data in your collections or in your admin records, you need to be really aware of it and need to make sure you're actually allowed to hold and process it in the first place. And sensitive special category personal data includes information about someone's race or ethnic origin, their political opinions, their religious or philosophical beliefs, their physical or mental health, their sexual life, their membership of a trade union, any alleged criminal offences, and also under UK GDPR, biometric and genetic data. So your genetic data, but also biometric data like your fingerprint or a picture of your face with facial recognition technology. So the kind of records we've got at West Yorkshire that might be affected by this kind of stuff in our collections. So special category data include things like court registers, hospital records, coroner's files, school admission registers and logbooks, which might mention individual pupils in some way about their disabilities or their behaviour or their family circumstances. Most of our collections that contain trade union records. In our admin records, well, our HR records, our own trade union records, stored by our trade union reps, our volunteer records where we have emergency contact details, first aid logs, appraisal documentation for staff, information about our users, our depositors and visitors that they may have given us when they're making inquiries with us. It's worth noting, again, in relation to personal data that's covered by data protection legislation, If you are in an organisation which is not a public authority subject to the Freedom of Information Act, then data protection law may not apply to personal data that you hold in what's called unstructured manual records, which is generally in sort of analog hard copy paper filing, which might not have an index or structure applied to it. But for practical purposes, I generally think that when you're developing procedures and processes that deal with managing personal data, it's sometimes sensible to include both types of record in the same way, just so that you're not having two different types of systems or trying to explain to trainees or volunteers what is unstructured manual personal data and unstructured manual records and what isn't. It's also possible that something you do may actually cause it to become structured, and I'll touch on that later. So underpinning the data protection legislation are what are the foundations known as the data protection principles. So under current legislation, there are 7 data protection principles. They appear in Article 5 of the UK GDPR, and they're right up front. And they're really important to understand. I will say the handbook that you're going to get has a side-by-side comparison with the principles as they were in the old Act. Broadly speaking, although there were 8 principles under the old Act and 7 under the new Act, nothing's disappeared. And some more things have actually been added. They've just been moved about a bit within the legislation. So it's really important to understand that personal data must be processed lawfully, fairly, and in a transparent manner. That's known as the lawful, fair, and transparent principle. It can only be processed for limited purposes as well, a purpose limitation. You can't get hold of personal data and then decide, we'll hang on to this in case we need it for something else later. Personal data needs to be adequate and limited to what is necessary in relation to the purpose for which they're processed. So that's the data minimization principle. And it's about, again, not collecting more personal data at once than you need to. Personal information needs to be accurate and up to date. The accuracy principle is really important, particularly when you're managing your admin records. Personal information must not be kept in a form that permits identification of data subjects for longer than is necessary. That's generally known as storage limitation. And that might be the one that makes people think, oh, well, you can't keep collections. You can't keep material for permanent preservation in archives if it's got personal data in, because if it was collected for managing attendance at an event, for example, you can't then use it for something else like being in an archive collection. But actually, some of the derogations that I'm going to talk about, the archiving purposes in the public interest, mean that we do actually have exemptions which allow us to do that when you're doing it appropriately. Personal information must be processed in a manner that ensures appropriate security. That's integrity and confidentiality. So you've got to keep personal data secure. You can't leave it lying about. You can't have information where people can see it. You can't have it held in a way that makes it insecure or accessible by people you're not aware of. And also in terms of sort of digitally held information, you've got to hold it securely in a way that means people can't nefariously access it without your knowledge. And then the final one, the accountability one, which is one of the new ones that came in, is the controller shall be responsible for and able to demonstrate compliance with the principles. In other words, it's not just enough to say that you're working properly with personal data. These days, you actually need, under the law, to be able to show you are. There are some separate provisions in Chapter 3 of the Data Protection Act that describe the rights of data subject access and so on. They've been strengthened. And there's also separate bits that refer to that international transfers of personal data as well. So they have separate things. So while they aren't in the main list of principles, they're still part of managing personal data lawfully in the UK. So the principles lie at the heart of the UK GDPR. They're set out right at the start of the legislation and the Data Protection Act, and they inform everything that follows. They don't really give hard and fast rules, but they kind of embody the spirit of the general data protection regulation regime. And as such, there are very limited exceptions. Compliance with the spirit of these key principles is therefore a fundamental building block for good data protection practice, and it's key to your compliance with the detailed provisions of the GDPR. Failure to comply with the principles may leave you open to fines. Infringements of the basic principles for processing personal data are subject sometimes to some of the highest tier of administrative fines, and this could mean a substantial fine from the Information Commission Office, although they do tend to try and be proportionate when they're handing out penalties like that. And one example I do have, when I do this training for our community archives group, one of the things I hand out is a paperwork from a monetary penalty notice that was actually handed out to a local history group under the old Act, the 98 Act, but the principles remain the same. In this particular case, a local history group had decided that they were going to take all of the records that they held on paper form about people who donated stuff to their collections, and they were going to make that electronic. They were going to set up a database and a spreadsheet whereby they'd be able to know about who gave them what particular material in their collections. That's a very standard thing to do. It's a good thing to do, and it's something that we advise our Community Archives Network group to do. And so they acquired a laptop to allow them to do this, and they were working with volunteers who were transferring that information from paper files to the digital record. Unfortunately, one of the people working for the group had the laptop in their possession when they were travelling from sort of A to B, and unfortunately the laptop was stolen. At which point it became clear that although there was a general password to access the laptop, the data within it was not encrypted in any way, which meant that they just handed over to a criminal information from their local community about people who had valuable historical stuff in their possession and in their homes, which was not an ideal situation. It became clear that they hadn't really considered anything about that. They hadn't done any training. They didn't have any procedures about anything in place. They hadn't considered whether they might need to encrypt the laptop, even though it's fairly foreseeable, I think, that a laptop might be something that someone would want to steal. They were fined, I think, in the end about £500, which in the grand scheme of things for an enormous business is not very much at all. But for a small local history group, that's a fairly chunky sum from your budget. And it's worth understanding the risks that you're taking when you are handling personal data and where you haven't got appropriate procedures and policies in place to make sure you're dealing with it properly. I've mentioned that you need to be handling personal data or processing personal data lawfully. So the lawful bases for processing personal data are listed in the Act, and there are several of them. They're in Article 6 of the UK GDPR. And the important thing to know is you must apply at least one of these whenever you want to handle personal information. Consent is the one that everybody's pretty much heard about because of all the publicity that went on before GDPR came in. But I will say that consent is not the only lawful basis and sometimes not the most appropriate lawful basis for handling personal data. So consent must be freely given and can be withdrawn, and it's worth noting that. But there are, as I say, other ways and other lawful bases for handling personal data. It might be as part of a contract. For example, if you're collecting personal information to send out tickets for an event, then you effectively have a contract with the people who are attending the event, particularly if they're paying for it. You might be taking someone's information because you want a paid copying service for records within your archive collection. You might even have contracts of employment for employees that you have. The legal obligations, so that's where you need to process personal information in order to comply with the law. One of the examples I've given there is health and safety law applies to quite a lot of organisations. You might well have a sign-in sheet for managing fire risk. And that's under basic health and safety legislation. Vital interests are quite important, and that's where you're processing or handling personal data to protect someone's life or well-being, generally someone's life. That can be a lot of the stuff you might be handling about people's health conditions and so on, if you're managing volunteers, emergency contacts, that kind of thing. Public task usually only applies to public sector bodies, and it's about where we process information because it's part of a task that we carry out in the public interest or it's part of our statutory functional duties. Legitimate interests have been clarified a little in current legislation. So the Data Use and Access Act laid out some recognised legitimate interests to clarify things. So that's things around safeguarding vulnerable people, responding to emergencies, preventing or investigating crime, national security, public security and defence, sharing personal information with an organisation that needs it for its public task or a function at their request. Most community and voluntary groups are unlikely to be relying on recognised legitimate interests in their day-to-day activities, but it is a legal clarification that was added to data protection law in 2025, so it's worth knowing about. But generally, legitimate interests mean that the processing is necessary for your legitimate interests as an organisation or the legitimate interests of a third party. And this is important, unless there is a good reason to protect the person's information which overrides those legitimate interests. Legitimate interest is not a blanket permission to process personal data. So you do always need to balance that legitimate interest that you might have in doing something against the rights of the data subject. In my archive service, we process personal data under a number of different lawful bases all the time, depending on what information we're collecting and why. Have we taken someone's personal details because we're dealing with an inquiry? Are we managing an event? Is it to manage something in our collections? Is it part of our being an employer? Is it to do with our volunteers? All of these ways in which we collect and process personal data might rely on different lawful bases, and it's important for us to know which ones we're relying on. It is very important for you as a group to understand your responsibilities under data protection law. So work out, for example, is your group a data controller? Do you decide what happens to personal data and what you collect? You may well be a data controller unless you're part of a larger organisation, which is considered the data controller. So your group's personal data for staff, volunteers, visitors and researchers and so on, and possibly some personal data in your collections may well mean that you're a data controller. If you work with or for other organisations, you might also in some circumstances be a data processor for some things, but you still have those responsibilities under data protection law to manage data appropriately. You might need to register with the Information Commissioner's Office. There may be a fine if you haven't. There is a tool in the section now for new guidance, particularly for smaller organisations, that helps you work out if you need to register with the ICO or not, for which sometimes there's a small charge. And there's a link to how you can do that, where you can find that information on the ICO website in the handout that's coming to you. You need to understand what personal data you have as a group and how you process it and what your lawful or legal basis is. As I said, consent's not the only one. So you do also need to understand where you're processing personal data under a different lawful basis. What's really important sometimes is, as well as understanding the lawful basis, you need to be able to tell people why and how you're processing their personal data and how they can access it. That's part of that fair, lawful and transparent bit. You need to be able to demonstrate you're following all of those data protection principles. That's the accountability bit. And also, quite importantly, you need to know who's in charge of what to do if something's gone a bit wrong. Fundamentally, the concept of data protection by design or by default is something that you should really consider. You need to build it in from the beginning of everything you do, from setting up your group to planning an event to planning a digitisation project or an oral history project. Your first thought should be, where's the personal data in this? Do I need to carry out what's called a data protection impact assessment? So that you'll find templates for doing data protection impact assessments linked in the handouts and also on the ICO's website and sometimes on the National Archives website as well. And that's a tool or a process you go through where you decide, okay, well, we want to do this thing. Is there personal data involved? Okay, if there is, how are we making sure we're doing it properly? How are we documenting what we're doing? Should we be doing it at all? And if there are risks around managing the personal data, how are we minimising those risks? Knowing what to do if things go wrong is quite important, partly because under new legislation, the time limits for making the Information Commission Office aware if you have a notifiable breach is now quite short. It's 72 hours from the discovery of the breach. But not everything necessarily might be a notifiable breach if something goes wrong, but it's useful for you to have those policies and procedures in place that help you decide, is this a point where we need to let the ICO know that something's gone a bit wrong? You need to have that accountability, those records of processing activities, so you know what you've got and how you're doing it. You might need to review your policies and procedures. You might need to make sure you're telling people about how you're looking after their data. You almost certainly will need to train your staff and your members. And you also really need to be quite clear on what's you, as in you, the group, managing personal data, and what's personal data that might be in your collections, because you might be managing that separately for archiving purposes in the public interest. And there is guidance out there as well. The National Archives offers guidance, and the Information Commission's Office offers guidance for groups, and obviously organisations like CARD, the Community Archives and Heritage Group, produce their resources list and training and so on, like this particular thing. And you'll be getting some of that guidance and pointers towards where you can find more of that guidance as a handout from this talk. But I've mentioned processing for archiving purposes in the public interest a couple of times now. So it used to be covered by Article 89 in the GDPR, and now it's covered by Article 84 AD following the recent changes from the Data Use and Access Act. And basically what it does is it makes sure that there's specific reference to processing personal data for archiving purposes in the public interest, and it modifies those limitation principles that would otherwise prevent the continued processing of personal data that wasn't originally created and collected to be an archive when it's no longer required for its original purpose. Having said that, it's not quite a blanket permission to collect, to hang on to anything you want in your archive collections. And it's not a blanket permission to be able to do whatever you want in your archive with personal data in your archive collections, because you still need to safeguard the rights and freedoms of individuals. And that might mean that you include restricting public access to items in your collections for a particular period of time that might include the data subject's personal lifetime. It's worth knowing that where you are processing personal data for archiving purposes, you might be exempt from some of the UK GDPR provisions on data subject rights and things like that. But you really do need to be sure that you're processing for archiving purposes if that's the case. The National Archives has produced, as I say, a guide specifically aimed at archiving personal data in the public interest. And now, following the recent act and new guidance, there's new guidance on the generally recognised standards for archiving in the public interest, which help you as a group demonstrate your accountability in that area. So that might include things like publicising who you are and what you do for transparency, having clear policies for where you may need to restrict access for a period of time to items in your collections, having a clear collections policy so you know you're only collecting in your archive collections the personal data that you need to, managing personal data that you care for in and out of your collections properly and in line with those principles. And all of that new guidance has got some really good checklists for what you need to consider as a group and things you might need to bring in. So this is just a bit more on that type of archiving processing and those safeguards. So when we're talking about archiving being done in the public interest, what are we actually talking about? So we're talking about trying to be able to show that you are collecting records for future research or educational purposes, even if you aren't in a position to give full access now. That is your eventual intent. Are you holding records to support long-term accountability, for example? That's in the public interest. Does your archive aim to preserve personal, community and corporate identities, memories and histories with the intention of making them accessible, which very much applies to the core ethos that drives many community archives groups? Having said that, where you are doing that, you still need to demonstrate that you have appropriate safeguards in place to protect the rights and freedoms of individuals. What that means is the processing, and remember processing does a lot of heavy lifting, it must not be likely to cause substantial damage or substantial distress to a data subject to whom the personal data relates. You also can't be processing that personal data for the purposes or measures or decisions with respect to specific individuals. And you have to ensure that appropriate technical and organisational methods are in place to respect the principle of data minimisation, which might well mean that you appraise archive collections when they come into you. You don't necessarily keep everything that's offered to you. It might be that you have a very clear collections policy on what you do and don't accept into your collections. But as I say, in the guidance that's now available, there are some really clear checklists to enable you to work out what you might need to have in place in order to make sure that you are meeting those safeguards and that you're handling personal data in your collections properly and that you're able to demonstrate that you are actually holding it for archiving purposes. And that, as I say, can involve things like access restrictions for a period of time on some items within your collections. It's also worth knowing, as I said, that where you can really demonstrate you're carrying out archiving purposes in the public interest, you might be exempt from some of those data subject rights. Generally speaking, that includes the right of access, the right to rectification, the right to restrict processing, the obligation to notify others regarding rectification, erasure, or restriction, the right to data portability, and the right to object. And also potentially the right for erasure. Having said that, even though you are technically could be exempt from the provision of right of access, if somebody comes along and says, oh, I think you've got information about me in your archive, I want to see it. It's still very good practice, both ethically and professionally, to do whatever you can to support a subject access request. So although as an archive service within our collections, we may be exempt from subject access rights of access, we do everything we can to support rights of access for an individual who's looking particularly for information about themselves. So that applies generally to material in your collections and not your administration. So for your administrative purposes, you may well be subject to those data subject rights. So you could be contacted by someone who wants to find out, well, I've been volunteering with your organisation for some time, can you tell me everything you hold about me? And you need to have a procedure in place to enable you to actually do that and answer that within the timeframes necessary. I've got a data protection example here I sometimes use with some of our community archives network groups. So how would you deal with the following? How should you deal with the following? So you're a community archive group and you've recently taken in an oral history collection about the village from the late 1980s. It's on analogue tapes. And you're planning to seek funding to digitise the tapes and make them available online, maybe, or through a listening booth, possibly in your community library. So you need to think about what you need to consider if that's your plan and that's your project. So ignoring any copyright issues, which I touched on last week, that relate to the recordings. The proposed digitisation introduces new risks, including the potential for the re-identification of individuals who are mentioned in those tapes. And reputational harm to contributors or to third parties who might be mentioned in the recordings. It's almost impossible to do an oral history recording on someone's life without them talking about the other people that they know in their life. And at the moment, particularly if you don't have the technology enabling you to access those tapes right now, if you don't have a tape recorder, you might not actually know the full content of the tapes. You don't know what risks you're running or what information or personal data might be in those. So the first thing you would do as a group is do a data protection impact assessment using the template links in the guidance. Ask questions about, were there any permissions gathered originally when this project was done back in the 1980s? What were people told about what would happen to their interviews and how they would be made available or looked after in the future? What's the content like? Does it mention third parties? Is there any sensitive special category data in there? Does John Smith start talking about his mother's health? Can you limit access to the files, to some of the files, and make some of them accessible? Should they all be open? And open to all? Should they be online, or should you somehow restrict or partially restrict the collection? If you do make it available, particularly online, can you take down information if somebody makes a complaint? Do you have the technology to enable you to do that? Do you have a way for people to contact you to make those requests? One of the most important things you need to do when you're considering this kind of project is to think about all these things, but not just think about it, document all of the decisions you're making so that you have that evidence to show that you did things properly and considered the right things. So a lot of things to think about with data protection. Working out whether your collections hold personal data of potentially living individuals, knowing what personal data you hold in your collections and your administrative records. Where did it come from? Why? Why have you got it? Is it on deposit? In other words, is there an owner of the material still out there in your collections, in which case that owner may also be the data controller? I mentioned earlier, data protection law only applies to information held in unstructured manual records if a public authority is processing. In other words, if we're subject to FOI, and that includes paper records that public authorities might not hold as part of the filing system. So it's possible, if you're not a public authority subject to FOI, that some personal data in your collections that is in unstructured manual records may fall outside the scope of data protection legislation. However, it's also worth thinking about ethically what you do with that information, particularly if you're embedded in your community. And I'm also going to say it is easier to manage a single approach to managing personal data in your collections, particularly around access and procedures and training and policy, than it is to have separate approaches to, oh, well, we can do this with this collection, but we can't do that with that collection. So generally speaking, and that's something that we apply in my archive service, so some of the collections we hold are subject to FOI, some of them aren't, so we tend to have exactly the same approach to managing access and access restrictions across all of those collections, simply because it's easier to explain to researchers and it's easier for us to manage when we're training staff how to deal with stuff. It's also worth bearing in mind that if you have unstructured manual records with personal data in your collections, and you decide to process the personal data by cataloguing them or indexing them or digitizing the records in a way that makes information in them really findable, including people's identities, you may actually be then applying structure which brings them within the scope of the Act. Do you tell people what personal data you collect and what you do with it? Do you have privacy notices and privacy policies? Privacy notices are kind of required under general data protection regulations. Do you have any of that special category data anywhere? Are you really sure what you're doing with it and that you need to hold it? If you are processing personal data at all, why? What's your lawful basis? Is it for archiving purposes? Do you train your members and staff on how to deal with personal data legally? That's really important. It's one of the things that comes up time and again when the ICO is investigating when things have gone wrong. First thing all staff they'll ask is, do you train people on what to do right? Have you got proof of that? How do you record what you're doing with personal data in your collections and in your administrative roles? Do you have records that show what you should and shouldn't be doing? And as I say, always important, who's in charge if it all goes wrong? You may well be too small an organisation to have a data protection officer, but have you got someone designated who takes responsibility? But as I say, there's quite a lot of scary stuff going on, but there are places to find help and there's lots of places where you can go for help. So the National Archives, for example, have developed a data protection toolkit for archive services. We've directed quite a lot of our staff to it. We also direct our Community Archives Network group to it. It's self-directed and anyone in a community archive group can get access to it. There's information on how to do that in the handout that's coming to you and also on the National Archives website. You can work through, it'll explain various bits of legislation to you, and then you can work through various scenarios about questions about how you would handle a particular situation. You can review legislation in detail and you can work out where your group can do things to handle personal data better. The National Archives will also produce their guide for archiving personal data, which gives you a lot of detail on what to consider when you have archive collections that might contain personal data of living individuals. So that's where you're caring for material that's less than 100 years old. And as I say, recently they've worked with the AHRC and various other people to develop the new guidance on the generally recognised standards for proving you are doing it, are doing archiving processing in the public interests, which of course involves a lot more checklists. And you'll be getting a handout from us that's got pointers to all sorts of further information resources you can use. One of which I've included, which some people might not be aware of if you're not subject to a Freedom of Information Act. So the regulator for data protection is the Information Commissioner's Office, and part of their job is to provide guidance on how the legislation works and what to do to comply. So there's lots of links in the handouts coming to you for their website, for particular sections on their website, and particularly sections aimed at particularly smaller groups rather than big businesses or huge councils. But one of the things that the ICO also does is they publish outcomes of what are called decision notices. So for archive services like my own, we pay attention to these as they're basically the outcome of freedom of information complaints. So where an archive service has said, oh, I'm sorry, we're not going to allow you access to that, and someone's made a complaint. And the reason this is important in this context of data protection is while freedom of information may not affect your group, one of the biggest reasons an archive service like mine might say, sorry, we can't let you access that item under the Freedom of Information Act is because it's exempt under Section 40 of the FOI. In other words, it is covered by the Data Protection Act. In other words, information in our records which is covered by the Data Protection Act is something we restrict access to and isn't available under the Freedom of Information Act. So if a researcher isn't happy about the fact that we refused access because of Section 40, because of data protection, we said something was restricted or closed, they can go to the Information Commissioner's office and make a complaint. The ICO will consider the law and the access request and make a ruling on whether the Archive Service was wrong or right to refuse access. So decision notices relating particularly to Section 40 made for archive services and councils or for the National Archives are really useful to read. They give you a good idea if your approach would be acceptable to the regulator or not. And I've put links in the handout to come to you, so some really key decision notices, particularly relating to archive matters, including actually the full one there, which is a West Yorkshire Archive Service decision notice. And also some hints on how you can access that decision notice database and narrow your search so you can have a look and find more ones relating to archives. That particular one that we were talking about there, the West Yorkshire Archive Service decision notice, was from a few years ago. In this case, someone came to our service looking at court records and they wanted to access information about a case from 1943. It was to do with a sexual offence, but they were actually seeking information about their own birth parents' names. This was one of those situations where, interestingly enough, the identity of your birth parent is sometimes their personal data and not yours. And we did, in fact, restrict access, and the Information Commissioner's Office upheld our decision to restrict access in this particular case. But you can read the full details of what happened in that particular case if you follow the link in the handout. So I've managed to finish a bit early, so I think we can potentially hand over for questions now. I think it might be a bit sensible if I just bring things down. If I end screen sharing that and just drop that. Hello. Stop screen sharing. Where have you gone? Stop sharing.